Good morning, everybody. Thank you very much for joining us here this morning. My name is Sarah Rooney, so I'm the Employer Engagement Officer with Mayo, Sligo and Leitrim Education and Training Board. As I said, I think most people have joined us. I'm just going to have another little look because I'm conscious that some people are still trying to log on. We have an hour this morning, so I really want to make the most of it. And thank you very much for signing up this morning and giving an hour to ourselves. Okay, where are we at? I'm just going to have a quick look at the lobby. Just make sure there's nobody waiting. Perfect. So as I said, we have an hour, so I'm conscious that we all get as much out of this hour as possible. I know that a lot of you have already emailed me some questions for our expert panel this morning, so thank you very much for that. So hopefully we all find this webinar really useful. So in terms of the agenda, I am going to just give you a quick overview on Mayo Sligo Leitrim ETB Skills to Advance and what the programme is about for those of you who just stumbled upon this webinar online on LinkedIn and may not be familiar with ourselves. And then we're going to hear from Paul Heverin, who's going to talk about the Pension Auto-Enrolment scheme. And then we're going to have a presentation from Loretta Kenny, who's going to be giving us some great insights on some recent employment law updates. And again, thank you. I know some of you have sent me questions as well, which we're going to have a Q&A at the end. And I'm going to hopefully get to all of them. So there is a chat box open, so please pop your questions in that throughout the presentation as well, and we'll hopefully get to all of them. So, like I said, my name is Sarah Rooney. I work as a part of a team of 3 employer engagement officers for Mayo Sligo Leitrim ETB. I have responsibility for the Mayo region and I'm based in our Ballina office. You can see my contact details here on screen, so please add me on LinkedIn if you haven't already, where you will see that we post regularly about new training opportunities on there available for businesses, or alternatively, if you email the email address on screen there, skillstoadvance@msletb.ie, you can reach myself and my colleagues Aidan Tighe and Orla Sweeney, who are based in Sligo Leitrim. So please feel free to reach out to us regarding your own company's training requirements. So Skills to Advance, it's a national initiative that provides upskilling and reskilling opportunities to employees. Our programs are fully funded, and the Skills to Advance program, it's run by SYS, and funding comes from the Department of Further and Higher Education, Research, Innovation and Science from the National Training Fund. And simply put, it aims to equip employees with the skills they need to progress in their current role or to adapt to a changing job market. And we work closely with small and medium-sized enterprises in Mayo, Sligo and Leitrim, and we help employers identify skills needs, and we invest in their workforce by providing fully funded training to their staff. And what's great is that once that they've completed the training, they receive a qualification. Our programs are accredited by QQI, and our awards are available right up to level 6 on the National Framework of Qualifications. Training is provided by ourselves and consists of short programs. And what's great is that it's delivered in a blended learning format with tutor support, and there's online digital resources available as well, which really enhances the whole learning experience. And crucially, we are very flexible in our delivery to suit both the employer and the employee needs. And I suppose Skills to Advance, it was established with the vision being that the ideal workplace in Ireland is that upskilling during one's working life is considered completely normal practice, and research shows that this does have a direct relation with enhanced job security. And we know that multinational firms systematically invest in the development of their staff, and research shows that they benefit hugely through improved productivity and competitiveness for their employees. So it's a no-brainer really that the SMEs would be actively seeking to upskill their employees too. So again, please make a note of our contact details. Feel free to reach out to ourselves. And with that in mind, just to give you a flavour of some of the fully funded courses that we do offer. Again, this is just a flavour to give you an idea of the sort of breadth of programs that we offer that are fully funded. So there's a really popular diploma in hospitality, supervision and leadership. And again, blended delivery, so a mix of online and classroom. We have a course in management spreadsheets. This one's fully online, 3 hours per week over 12 weeks. So just to give you an idea of how they operate, we have a new program starting at the end of this month, mentorship practice, and this one is QQI level 6, online live classes, and this one is delivered 4 half days over 8 weeks. And again, this one's looking at examining mentoring theories and applying the skills back to your own workplace and your own job. So if you're somebody that onboards new staff in your organization, that one would be really good. Some other programs that we have on stream at the moment, there's environmental sustainability in the workplace, a cert in leadership and management. So this one looks at managing and implementing change and motivating people, really, really popular. And then a data analyst diploma as well, just to give you an idea of the types of courses that we do. So please reach out. And if there's any specific training in your own organizations, fire us an email and we will be happy to come back to you. So again, thank you very much for listening to myself and a little bit about our Skills to Advance program. So what I'm going to do now is hand you over to Paul. And obviously, if there's any questions you have in regards to what I spoke about, please do pop a question into the chat box and we'll hopefully get to them at the end. Paul, are you okay to share your screen? Perfect.
Okay. Thank you. Thank you, everyone, for joining us this morning. So I'm covering the area about pension auto-enrolment. So I'm just going to make this screen a bit better. So my name is Paul Heverin. Can everyone see that? Yeah. So the key topics of today's presentation is just a tiny bit about SYS, why are pensions being made compulsory, auto-enrolment itself, pension versus a pay rise, group pension was an alternative to auto-enrolment, and executive pension and PRSAs, which are other alternatives available as well. Retirement options. So when you get to retirement, what happens? And frequently asked questions and useful references. We in SYS, we started in 2015. We have over 300 million in assets under management and we have over 7,000 clients. We're part of a group and we have offices nationwide and we have 40 members and staff. When I joined 18 months ago, we had 25, so we're at a fast growing rate. Why are they making pensions compulsory? Well, in 1970, for every one person in retirement, there was 7 people working. 40 years later, in 2010, there was 4.5 people to every one person retired. And to project in 2050 that there will be 2 people working to every one person in retirement. So the way the pension scheme works at the moment with social welfare and the OAP pension can't exist in 2050 because there'll be 2 people working to every one person in retirement. So with that in mind, from the auto-enrolment is going to be introduced for everyone in Ireland. And the start is on the 1st of January 2024. All employees between 23 and 60 earning over 20,000, and there's an upper limit of contributions of salary of 8,000, have to be in the scheme. There is exemptions for people who are already in a pension scheme who are match or better the employer requirements at a minimum standard. So the compulsory auto-enrolment will be phased in over 10 years. So every 3 years, the contributions by both the employer and the employee will raise by 1.5% every 3 years. So here is a table in the first 3 years. It will start off at 1.5%, up to 3%, up to 4.5%, and ending up at 6%. So in 2034, you'll be putting 6% of your employees' pension employees' salary into a pension for them. So the Department of Social Welfare have projected that a worker earning an average of 35,000 euros will build up without any growth about 293,000 euros over their working career if they started at 23. So a bit about auto-enrolment. The pot follows the member. So that means if an employee is working with your company or business for 5 years and move on to their next job, that pension follows them. The pension enrolment will, there'll be 4 companies offering the scheme. As of yet, we don't know who they are. And they will have an options of 3 funds. And as of yet, we don't know what them 3 funds will be. But I'm guessing it'd just be low risk, medium risk, and higher risk. But that's just a guess. Employees paying tax of 40% should not be in auto-enrolment. They should be in a group scheme or PRSA or an alternative pension. Group pensions, employers can offer extra benefits such as life cover or income protection. This can help with retention of key members of staff. So the way pensions work at the moment, if you pay tax at 20% and you put €1 into a pension, that is costing you 80 cents and revenue are putting in 20 cents. The new proposed auto-enrolment, everyone who joins it, if you put €1 in, even you're paying tax at 20%, that euro would cost you 75 cents because the government are going to put in 25%. But in the current pension scheme, if you're putting money in and you're paying tax at the higher rate of 40%, every euro you put into your current pension, it would cost you 60 cents and the government will put in €1. So why would you join the auto-enrolment scheme? It doesn't make any financial sense. You're straight away, you're down 15% on your return. There's also an argument that you should, when your employees look for a pay rise, look at a pension. And if you had, all the figures I'm doing today, I'm doing wrong figures just from maths point of view. But if you had an employee on €50,000 and you both agree to give them a pay rise of €5,000 and the employee would then get the pay rise, they'll get an extra €5,000 a year in their salary, but the taxman takes 40%, universal social charge and PRSI, and they end up with 2,400 in their hand, which is 52% down on the agreed pay rise. But this will also cost the employer because they have to pay their employee €5,000, pay PRSI at a higher rate. So that's going to cost the employer 5,553. Now, if you bring pensions into the scenario, if you made a €5,000 pension into the employee's pension pot, €5,000 goes in. And this would cost you, as the business expense, €4,375. So it's €1,178 cheaper than giving them a pay rise. So which would you prefer as an employer, to give them a 5,533 cost to the business or a 4,375 cost to your business? The next thing then, and then even as an employee, I prefer, if you are on a bonus system, to put half your bonus into your pension, because half your bonus will go in, and the other half have that taxable. The other alternative then is group pensions. And this is, let's say the 1.5% of your salary works out at €100 a week. So every week, your employer will take €100 out of your payslip. Revenue will put an additional €67 on top of that. So that's €167 a week going into your pension pot. But your employer needs to match that. So your employer also has to give €167 a week into your pension. So combined, that's worth €334 a week going into your pension pot. So this is someone paying tax at first time. So I always say to someone, if you have €100 and you put that into the bank on a Friday or wherever you save, will you get a return of €334 the same day? And the answer is no. So people should look at pensions as an investment, as part of their investment portfolio, not as a pension. because the return you're going to get for that, if your employer is matching your payments, is way more than you would get on your regular savers. Then if you're the boss or the director or CEO of a company or a sole trader, there's also avenues available to you. So if a company had an operating profit of 100,000 euros, revenue will allow the company to put money into a pension pot on your behalf. So let's say, for example, we decided that we put 30,000 euros into a director's pension. That means the new operating profit of the company is now 70,000 euros instead of 100. And this 30,000 euros is now in the directors of the CEO's pension pot or employees' pension. So if you're in a position for a company to do that, 30,000 euros by 20 years is 600,000 paid by the company, not by the CEO or the owner of the company. And so this is just the advantages of putting money into the pension. The company pays the payment, not the person. So this is a tax efficient way to extract wealth from a company. Pensions are treated as a business expense. You can fund up to 2 million euros per director, per employee, or a family member for their pension. And pensions grow tax-free. So once your money goes into your pension, there's no dirt tax, there's no universal social charge, there's no exit tax until the pension matures. You can add, for a group scheme, you can add the benefits of provisions to prepare for loss of key personnel due to illness or death. So I had a client up in Dublin, and their number one salesperson generated €1 million of sales a year. So I said to the manager, what happens if he gets injured or ill or dies? And he goes, the company would go under. So we put a policy in place that if he were to pass away or to get sick, the company would get paid €1 million for that year. At least to have a year of income coming in to replace that person. So you get to retirement. How do you access the money? So there's two ways, but this is our preferred retirement option at the moment. So let's say someone gets to retirement and with growth, they have 400,000 euros in their pension pot. Again, I'm just trying to pick a round number. So under the current revenue schemes, you're allowed to take down 25% of that money tax-free. And so that means the person will get 100,000 cash into their hands, no tax, no PRSI, no universal charge. It's 100,000 straight into the hand. Then they have 75% left over, and in this case, that's 300,000. That must be under revenue rules be invested in what's called an approved retirement fund. So that 300,000 is invested, and if you got a minimum return of 3% growth on that 300,000 every year, that will give you a pension of 9,000 euros. Now, under the current pension scheme, social welfare will give you an additional 13,000 on top of that. So that will give you a pension of 22,000 euros in today's money. I do not think that pension will be 13,000 for us, retiring around 2045, 2050. It's going to be less. And hopefully you have a pension of 22,000 and your partner has a pension of 22,000. So frequently asked questions are, can I choose any company or fund choice? Auto-enrollment? No, there's only 4 companies with 4 choices. For an alternative traditional pension, yeah, you can go with any insurance company in Ireland and there's hundreds of funds. Is the pension transferable? Auto-enrollment? Yes, it is. Pensions, yes, but you may need advice on this. It may not be in your interest to move it, but most cases it is. When can I access my pension? So, sorry, you can't see that. So it's from the auto-enrollment. You can access your pension at 66. If the pension age increases in the future to 67, 68, 70, that's when you'll be able to access the auto-enrollment. Pensions, so a PRSA, you can access from 50. Group pensions, it's typically 65, and executive pensions, then it's also 50. So these are websites you can get more information on. So the Pension Citizens Information, the government.ie, auto-enrolment, and Pension Auto-Enrolment is also on the IBEC website, and they have a piece on it there. I will have a summary of today's webinar. So if you want a copy of it, you can email me at paul@sysgroup.ie. And everyone that attends today, if you send me an email with your name, your company, or business, and phone number, we'll enter you into a draw for a hotel stay in Ireland. So we just want to make sure, are you prepared? Do you know what's around the corner? So group pensions and protection quotes are currently taking 2 months. That's normally 2 weeks, but the amount of companies trying to prepare themselves, it is gone up to 2 months. And expected 750,000 people will be taking up a pension. So we need to start moving on this straight away. And do you know which pension scheme is the best for your business? And you need to make sure that you know that. So here is a QR code. If you want to take a screenshot of that, that would bring you directly to the website for the draw. But also, you want to just email me your details. I'll enter you in the draw. It'll be easier for you to do, I think. And thank you very much. And I'll answer all your questions at the very end.
Thank you very much, Paul. That was really interesting. So there are some questions coming in on the chat, which is great, which we'll get to at the end. And definitely send an email to Paul. Great opportunity to win a hotel stay there. So thank you very much for that, Paul.
Awesome.
It's great. Loretta, we're going to go to you next for your presentation. Let me know when you want me to share.
Yeah, you go ahead. Thank you, Sarah. So good morning, everybody. So my name is Loretta Kenny, and I'm a HR consultant based here in Mayo. And a little bit about, and I'm going to talk today about the recent changes and the impact on employers with a lot of employment legislation that has come through, particularly since COVID. And the difficulty that employers have in navigating and staying on top of all of these employment laws. It's even hard for a HR person, never mind an employer trying to run a business. So I understand your frustration. So hopefully I can help you a little bit today. And also just a little bit about the Workplace Relations Commission. I'm not going to go into too much detail about that, but just in case any of you need to know, what their role is and how they interact with employers. So just a little bit about myself. I'm originally from Castlebar, but I worked in HR roles in, you can go to the next slide, Sarah, in HR roles in New York for 25 years, plus over 25 years actually. And a lot of that was in corporate, but also in SMEs. And I'm back now and I help companies throughout Ireland with all of their HR needs. And when I was in the global bank in New York for 10 years, they were going through a merger. So I successfully brought them through a merger. So I'm very familiar with restructuring and redundancy and all that kind of stuff. I also was the lead investigator for the likes of discrimination or harassment claims within the bank. So I would work with our internal solicitor on all of those. So again, I'm familiar with severance agreements and mediation and that kind of process. I also supported departments on their HR as well as a generalist or a specialist. And I worked with a lot of policies and training programs, etc. Okay, Sarah, you can move on, please. The next slide.
Correct.
Because I forget what's on it.
There's a little bit of a delay for some reason.
Oh.
Get to it.
Okay, I just wanted to, I'm not going to go through these, but these are some of the common laws that you would have seen probably as an employer, or you probably need to make yourself familiar with some of them at least, because these have been in place for a long time, most of these. I'm not going to go through them, as I said. I want to concentrate on the ones that have changed because in the interest of time. But if you go to the next slide, Sarah.
Yeah.
And I just want to talk a little bit about the Workplace Relations Commission. So they're the governing body for the employer-employee relationship in the workplace, as you know, many of you probably know already. And this was the 2019 report. And so there's complaints have been on the rise, and hearings have been on the rise. And you know, the amount of wages that were recovered in 2019 was 3.9 million, and that's for minimum wage breaches. So I'm sure you're all on top of the new minimum wage for your industry and for the category and age and whatnot for 2023 as it just went up. And there was a lot of cases convicted in 2019, but there was also a lot of employers that actually weren't convicted because they had proper procedures in place. So I just want to go through a little bit of that in a few minutes. So next slide, Sarah. So this is really what employers should be focusing on. It's just to get this balance right, because the Workplace Relations Commission is not necessarily out to get the employer. They're there to make sure that the employee is being fairly treated and reasonably treated. So if you ever have a situation with an employee, put yourself in the employee's shoes and say, you know, am I being fairly treated? Are they being reasonable with me? No matter what the situation, no matter how grave it is or how sensitive it is, or and always get the advice before you make a decision. But it's just to get that balance right in terms of your responsibilities as an employer and, you know, your rights as an employer, and also the employee's responsibilities and their rights. So next slide. You can go back one. Oh no, sorry. Go ahead. So this is, I just want to give you again, I'm not going to go through this, but in case you haven't seen a list of what the WRC will ask the employer for, they can come on site to any workplace and ask for this information. Sometimes you might get a letter. Sometimes it's just they pick an industry or a location and they want to see if particularly part-time employees, if they're getting their annual leave pay or getting bank holidays, whatever their entitlement is. They want to make sure that, and the minimum wage, they want to make sure that they're getting what they're entitled to. So they would actually often interview employees as they are on the workplace. So you have to be careful that you're doing what you need to be doing as an employer. And for example, timesheets, that's a big one that some of my clients has come to me. They've been audited by the Workplace Relations Commission. They're all stressed out. How are we going to deal with this? We don't have contracts. We don't have policies. So I help them, and oftentimes I've got them through it in 3 days. I've got them up to speed on what they need, and I've liaised with the WRC auditor to help them because they're so stressed out and they don't know how to answer questions. So if an auditor comes in, the best thing to do is basically say, listen, I can't handle it right now. Can you come back? And then you get the advice, you know, because you need to talk to somebody who can navigate you through it. The next slide, please. These are just some of the sample of the penalties or fines to employers if they get caught, if they're convicted. So, for example, if you don't have a terms and condition or a contract to an employee within 5 days now of hire, it used to be 2 months, that fine can be up to 4 weeks salary up to €5,000. If you've no policies or procedures in place and you haven't given them to the employees within 28 days and there's an unfair dismissal claim, that cost can be up to 2 years salary, and that's limited to the financial cost. So if the employee is out of work for 4 months, it could be 4 months salary, that kind of thing, if they win. So there's other ones there, like if somebody is applying for a job and let's say they're part of, you know, the 9 grounds for discrimination, like they're female and they hire just all males, or they don't hire any non-Irish people or whatever. If they can prove that, they can actually make a claim and earn or get 13,600 in a successful claim. There's a few other ones there as well. The remedy varies, but just to give you an idea. So we can go on to the next one, Sarah. Okay, so these are some of the changes in employment law. And again, this is only in the last few years. I'm not going to go through them all because there's just too many in the interest of time. I'm just going through some of them that were highlighted in feedback on the survey, etc. So just on the terms and condition of employment, so all employees, regardless if they're part-time, fixed-term, seasonal, full-time or whatever, they all need to get a contract or a terms and conditions of employment. And a lot of the information is required to give them within 5 days of hire. Again, that used to be 2 months. It's now 5 days. It's really important that you do that. First of all, it's easier to get an employee to sign a contract when they first start, because I find oftentimes if they're there for a while, they might have an issue or a problem signing a contract or whatever. There might be anything wrong with the contract, but there might be too much information. I suggest try and keep it as simple as possible for employees so they understand it, and it protects the company at the same time. And have most of your language in the employee handbook, which you also get them to sign. And probation period is now only up to a maximum of 6 months. Many of you may not know that, but it has changed. You could expand it up to 12 months, but now it's up to 6 months max. So what you have to do with that is just make sure that going forward you have that language in your contracts and in your handbooks and whatnot. The parents' leave has just gone up to 7 days. It was 5 days, and that's actually expected to go up to 9 days. The sick leave pay, as you probably know, came into play 1st of January 2023. So it's 3 days in this year, 5 next year, 7 2025, and up to 10 days in 2026. The important thing about this is, your contracts probably say if you didn't pay for sick leave before, they probably say that we don't pay for sick leave. Or you might say, we pay up to a maximum of 3 sick days a year or something, but it's probably not. You need to review that to make sure it's in compliance now with this new law. But the other important thing is your policy must be clear in terms of when they need to bring in a sick cert, because this law allows employers to ask for a sick cert after day 1. So if you're out sick day 1, the employers can now change their policy and say, maybe it used to say, you have to bring in the sick cert after day 2 or after day 3 or whatever, or may be required. You can change it now to say, well, you must if you want to get paid for it. Now, if they bring in a sick cert after 3 days and, they don't bring it in day 1 and day 2 and your policy says you must if you want to get paid, well, then you don't have to pay them for day 1, 2 or 3. But you have to make sure your policy coincides with what they're actually doing and make sure you're practicing that. For 50 employees and above, there's a few changes, and I'm not sure on the people here today how many fit into that category, but you need to just follow up on those areas: code of practice on equal pay, gender pay gap reporting. So right now, that's for 250 employees and above, but it's expected that employers with 50 employees and above will have to report on the gender pay and equality. And the protected disclosures has already changed on the whistleblowing. So that's just extended to the type of person that can actually file a complaint. And that fine is up to 5,000. The payment and wage tips and gratuity. So if you're in the hospitality industry, you have to put notices up now in terms of how they are going to be allocated to employees, and you have to communicate with employees how their tips are going to be allocated and service charges. They cannot be part of the normal pay. Okay. Mandatory training is another one that just was legislated. So if there's a precondition that an employee has to have certain mandatory training and you have them as an employee, you have to make sure they have that training, and you have to make sure that you actually provide them the time to do the training and at no cost to the employee. So manual handling might be one, but there's others like certifications for certain things. So that's something else that you could look up and make sure that you're in compliance with that. The exclusivity clauses, that means, you can't disallow an employee for taking up another job. It has to be subjective and reasonable. So in other words, if somebody's working for you and they want to take on a second job, if it's not really interfering with your business and it's not causing harm to your business, etc., you can't just say you can't work. You have to provide a reasonable explanation why they cannot do that. So if you have an employee, you have to give them advance notice of when they're supposed to be working, their hours and schedule and whatnot. But also, if they have specific jobs that they need to have done, to put it in writing so they're clear when the job is due, deliverables are due. For the bigger companies, there's a transfer legislation that came through. So as applicable, if you have an opportunity for an employee to actually allow to be transferred after 6 months of hire to another department that's more work-life friendly, you have to allow them to apply for it and put in writing, why you can't allow them to transfer. Okay. The sexual harassment the policy is basically the same. You can't, allow that in your workplace, but you are asked to designate a non-HR senior person to be like a go-to person or an advocate for people that might have a complaint in that area. The minimum wage is $11.30, as you probably know. The remote working and right to disconnect. So that came in during COVID. So it's really crucial that you have a policy, an application policy in place, and that you actually communicate that to employees. And it's actually good for the employer as well, that you make sure that you actually have written down all that is required from the employee if they're working from home. There's a lot of things, like data protection is just one of them, but a safe environment, they're not tripping over cables, etc., etc. You're not going to be able to go out to each person's home and examine them. So the best thing to do is have a policy in place, detailed policy, and have them sign it, etc., just to say that they're familiar with what's required from them and that they're following the rules. And then the auto-enrolment pension. So as Paul was talking about, the new auto-enrolment coming in January 2024, from a HR standpoint, you need to make sure that your contracts and your employee handbook is up to date with that. So for example, for my clients, I had a look at their contracts and the handbook in terms of the sick leave pay and the other policies that we just talked about, the changes and the auto-enrolment. So rather than change it again, because the legislation is actually not finalised, it's due to be finalised in July, but that's up in the air right now. But what I did was I just put in the language now that actually covers them. For if it is enacted. So I kind of put in the language that they don't have to actually change the handbook again mid-year. And the work permit application process used to be anybody outside the EU, they would have to apply for work permit, but also for resident visa. They're actually trying to make that one application process and make it easier for employers and these applicants to actually apply and make it more efficient. And obviously, you know about the new public holiday that was added this year. I didn't add that one there, but you probably already know about that, St. Bridget's Day. That's 10 public holidays. You can go on to the next slide, please. I just wanted to talk a little bit about the dismissals and disciplinary procedures and constructive dismissal. So for those of you who don't know, so constructive dismissal is when an employee actually resigns from the company, but they feel that they had no choice but to resign from the company because either working conditions were so bad or they were treated so poorly or whatever, right? So if they went to the WRC with a complaint, these are some of the grounds that they could use to file a complaint. So demotion, reduction in pay, or refusal to pay for overtime, poor working conditions. If you remove certain job functions, unless you have a good reason for doing so. And again, if you don't document stuff from a HR standpoint, it just didn't happen. And a WRC standpoint, it didn't happen. You make sure you document everything. And it's good for the employee as well. That it's clear, it's transparent. The sexual harassment or there's abuse in the workplace, and or if an employer doesn't follow fair procedures, or they're slow on following up on a complaint or a grievance, right? So even though you might have an employee handbook and you might have a very good policy written, if you're actually not following that policy and practicing that policy, you could get into trouble. And so in 80% of the cases, employers, they fail to follow proper procedures. So it doesn't matter how bad the conduct. So I had a case where somebody stole something, right, and they were caught with the goods. They cannot fire that person on the spot. They have to. They could suspend them on paid leave, but they have to put it in writing, a disciplinary meeting, invite them, allow them to bring somebody, and all of their rights in that letter, bring them, allow them to actually defend the situation. And then you have to take that information and consider it and then respond to them within 24, 48 hours or whatever, reasonable time or whatever. But if you don't do that, they actually might win a case if they go to the WRC, even though they did wrong. Even if it's theft or something else, or hit somebody in the workplace, whatever it is, you make sure you follow fair procedures. because that could be a hefty fine, and it could be up to 2 years' salary. Okay, next slide, please. Now, so these are some of the ways that employers can protect themselves from fines or lawsuits. So make sure your contracts are up to date. So again, in the contracts, if it says, we don't pay for sick pay, or, something about the pensions, and there's other language in there now that actually is not in compliance. If you have a good lawyer, if they read two meanings in whatever you have in the contract, maybe you have something in the contract and you haven't sent out a memo in amendment or whatever, you could get in trouble with that. So you need to have them reviewed and make sure they're up to date, and you need to make sure your employees have a current job description. So identifying what their job title is and what their role is, and the job title needs to match what's in the job description. Because if it's not, if they change the job title, they really need to get a new contract. Review and update the policies, and make sure you get employees to sign the handbook acknowledgement form. The sick leave pay, again, indicate when they have to submit a sick cert. And by the way, make sure you keep records. You're required to it depends on the actual HR document that we're talking about, but after an employee leaves, so during their employment and after they leave, a lot of documents you're required to keep maybe 4 years, and some of them are actually up to 7 years for certain maternity leave and whatnot. So you probably understand the minimum wage for the various age and the industry categories, and we mentioned a bit before about 50 employees and above, just to review some of the new legislation that came through on that. We also talked about the hospitality, to make sure you post how the tips and service charge or gratuity notice are allocated, and review the probationary policy and the practice. So again, if you have current contracts or a handbook and it says that your probation, it's usually maybe 3 months or 6 months, but it can be extended up to 11 months. You can't do that anymore. It's 6 months max now. So you need to review your handbook to make sure you're in line with the legislation. Provide the training if there's if it's legally required. So if you hire somebody and they didn't have all the licenses or whatever, but they need it for the role, so it's a precondition that they need that for the role, then you need to make that available for employees at no cost to the employee. Now there's probably some exemptions to that, but just to give you an idea. The exclusivity clauses must be reasonable, and communicate to employees in writing when work is due. Like that's big jobs, that it's critical that they get it by a certain time, or else, it puts the company in jeopardy and then they have a disciplinary or whatever. To avoid that, just communicate in writing, if you can. It could be just an email or, a couple of bullet points or whatever it is, but if you have it in writing. If there's an opportunity to do an application, just make sure that you allow the employees to apply for that. So that's me. Again, to get more information, you can go to the WRC and IBEC as well, no more than what Paul mentioned, for more information. And I'm available as well if you have an issue in your workplace and you don't want to say it publicly. You can definitely contact me. I think Sarah's going to share our information. So thank you very much.
Thank you very much, Loretta. Really, really interesting again. Okay, so we have some time here to go. Let's jump into the Q&A because some people have popped some questions in the box. So the first one, Paul, have revenue guidelines for how much you can assign to pension instead of pay rise? There have been issues in the past where they can consider that it is a salary sacrifice scenario.
Yeah, so that's more for directors and owners of companies where they may make 100,000 profit and their salary should have been 100,000 and they reduce it down to 50 and put the balance into a pension. So that's not allowed. But in January of 2023, they changed all the laws, and you can put as much as you want into a PRSA. So we had a client who had 4 children and he put 100,000 euros in each one of his children's PRSA. Their children are only part-time workers in his business. He's allowed to do it. He did it. So that rule it doesn't apply. Now you can't cut your salary down, but the PRSA option is an option there for you going forward.
Okay, thank you. Another one here, Paul. What if you don't live to retirement? Is it transferable to family left behind?
So the roundabout answer is yes, but to a spouse, before it's pre-retirement or post-retirement has slightly different rules. But yeah, it goes on to your family, then your estate. But some people may be taxable and others may not. Your spouse normally gets it tax-free, but it may also turn into a pension for your spouse depending on exactly your scenario. But again, when you get a review with a financial advisor, that is one of the areas that should be boxing off, and just make sure you understand the options at the end of retirement.
Perfect. And again, Paul, do you think January 2024 is realistic for auto-enrolment to be in place?
There was an article there about 2 weeks ago saying they're on course for it. So they haven't said they're not on course. So I would imagine if you don't hear anything by July or August of this year saying it's going to be pushed back, it's going ahead. But you have to look at it as 750,000 people and being signed up on the 1st of January 2024. Is that realistic? And, you know, probably the answer to that is no, unless they have an amazing system they haven't told us about.
Okay, thank you very much. Okay, Loretta, there's one here for you. You may have answered it already in the presentation. Can you extend the probation period past the 6 months if performance is an issue?
No, but what I would suggest is if you don't know if somebody's not going to make it in 6 months, you know, you're not really managing them properly, in my opinion. You can still dismiss somebody, you know, within 12 months. You don't need to extend the probation period to do that. So you would just manage them. So you would give them very clear feedback in writing.
Okay, thank you. Again, Loretta, in relation to employment contracts, does a single change to the existing terms and conditions require the issuing of a new contract, or will an addendum to the current contract suffice?
So it all depends on what that change is. So, for example, for the sick leave pay, I have an employer with they have about 80 employees. They did not want to go through the process of issuing 80 new contracts because a lot of them were only working. It's a cleaning company, so that some of them only work 5 days or 5 hours a week. Some of them work 20 hours a week, whatever. So what we did was we have a documentation in place that we sent out to all of the employees with the information and who we sent it to. So they were the existing employees, and then going forward, obviously, it's changed in the new documentation. But rather than go through that whole process again, yeah, that's what we did. So it all depends on what that change is. If it's a job title, or if they're getting commission, yeah, I would definitely change the contract. Because that's a substantive change just for that person. Mm-hmm.
Okay, Loretta, just to clarify, is the parents' leave for 7 weeks?
Yes. Did I say something different? I apologize.
I think you might have said 7 days. No, that's perfect.
Oh, sorry.
Great to clear that up. No, yes, thank you for putting the question in. There's a couple of questions here that I might actually forward on to you both directly. There just might be a bit of detail needed there, so I'll email them both to you after, if that's okay, Paul and Loretta. Some other questions that I got emailed. Loretta, how long are you required to keep HR records and documents?
I kind of mentioned it in the webinar. It depends on the actual nature of the HR document, but it could be up to 7 years. So I actually have a list. I'd be happy to share it with anybody who wants it. It actually is a list of how long employers are required to not only just save HR documents, but also other business documents. Okay, so perfect. They can contact me directly if they want. Yeah.
Brilliant. I'll pass on your details. Paul, one came in. You may have covered it. I work for myself and have no employees. Do I need to do the auto-enrolment?
Yeah, the law says you have to put 1.5% of your salary into it. But if you're paying tax at the higher rate, a PRSA or a personal pension plan would be the ideal route for you to go. At least you can have control over the pension yourself.
Okay, perfect. Another one came in for Paul. Can I pay more into a pension for my management team and key salespeople?
Yeah, so when you're setting up auto-enrollment, we don't know the answer for that yet. So we were told the minimums you have to put in, but we weren't actually given the legislation for the maximums. It would be commonplace for different level of management and staff to get different pensions paid into their pensions. So, for example, you had a deli, and the staff on the floor, you may put the 1.5% in, which you're required to do by law, but your manager, you may say, right, I'm going to put 5%. My store will not work without him. So you may opt to put 5% in instead of the 1.5%.
Thank you very much. Another one came in via email, Loretta. What do I do if an employee refuses, to sign an employment contract? So I think you might have touched on that as well a little bit.
I didn't actually.
Okay.
You fired them. No, I'm only joking. No, in actual fact, by law, the employee is not required to sign the contract. And that's why I said it's better that you get them to sign it when they start, because then, there's generally no issues. But let's say you have an employee, and I've had clients like this. They've had an employee on staff for like 6 years, 10 years, whatever it is. And they might not have given contracts before, or maybe they just need them to be up to date, and the employee doesn't sign it. So I just provide a memo to say that they've received it and they signed it and opted not to sign it. And then just file that with the contract, because the fact of the matter is, when they're coming to work and accepting a pay check, they've actually accepted the terms and conditions of employment. So that's the easiest way. Now, I would be concerned why somebody doesn't sign it. And so I work with my clients just to see what the problem is with the contract that they don't like, because I actually keep my contracts quite simple for my clients so that they understand it. The employee, there's no tricks. They don't feel like they're tricked or whatever. So I think that works better.
Perfect. Thank you. And then another one as well, Loretta. How do I deal with, or have you any advice for an employee who suddenly has a problem with lateness and continued absences?
Okay, I've had that, and some of them turn into a long-term illness or whatever, which is very sensitive or whatever. But for some of them, it's just something that's going on at home. It's nothing to do with the workplace, or it may have something to do with the workplace. You don't know. But if I had an employee and they were otherwise a good employee up to a certain point, I would certainly be more concerned about why it's change in behavior as opposed to, the work itself. So that's the first thing I would do, is ask them, is there something going on? And a lot of employers have an EAP program, which is an employee assistance program, which is really beneficial because it's a confidential line of support for an employee, whether they have financial difficulties or difficulties at home or whatever. And it takes the employer out of the loop, if you will, but it'll help. The goal is to help the employee with whatever it is that's going on, and encourage them to be able to handle it and come to work or whatever. But I certainly would counsel them informally first. Now, if it's a new employee, obviously, you treat it straight away, nip it right in the bud the first time. That if they don't have a valid excuse or whatever it is, I would nip it in the bud and just say, it's not acceptable. Or if they need you to maybe accommodate them, then have that discussion and see if it's feasible.
Perfect. And then one last one, which actually came in from a couple of people in a roundabout way, Paul, is this is an extra cost on my business, so the auto enrollment again, that I cannot afford. Is there any way around it in this case?
No, unfortunately not. There's no way around it. You have to do it. You have to put it in place. So when you're doing up your budgets for 2024, you need to build into the cost. There's an extra 1.5% on top of your payroll. Now, like I said earlier, I think that someone alluded to as well in one of the questions, maybe treat it as part of a pay rise as well, and say, look, instead of giving you a 3% pay rise, I put it into a pension, and at least it's more tax efficient for you. The employee has to agree with this. You can't just decide you're going to doing it. So that'd be more Loretta's part of it. But you can't just turn around and say, look, wherever. But you need to budget it that now, and every 3 years, that's going to go up 1.5%, up to 6% in 10 years.
Okay, thank you. And I see one last one come in the chat, so I'm going to fire it to you, Loretta. Can an employee start working before Garda vetting is complete?
Interesting question, because I actually had a client that this happened to. My advice to my client was, in this situation, the applicant or the new employee was working with vulnerable adults. And so in that case, guards vetting is really critical if somebody's working with vulnerable adults or children, and you're not supposed to allow them to do that if they need to be guards vetted. So I wouldn't allow it. If you already made arrangements with them, maybe they could work from home and get up to speed on the company and the inner workings of the company or whatever without having any connection with the vulnerable adult or children. So you could maybe work around it that way. But but in another company, if a person is not working with vulnerable and you just have a policy of guard vetting for whatever reason, you might be able to work that out. So it depends on the situation, really.
Thank you very much, Loretta. So thank you very much, Loretta and Paul. That brings us nicely up to 12 o'clock. And thank you very much, everybody, for joining today. And like I mentioned earlier, I'll pop you all an email with Paul and Loretta's details if you do have any follow-up questions, just so you have them to hand. But other than that, thank you very much. And this is episode 1 of our webinar series. So we'll be holding another webinar next month. So keep an eye on that one. The next topic is going to be wellness in the workplace. So again, I know really topical at the moment as well. So thank you very much, everybody, and have a good rest of the day.
Thank you, everyone. Cheers.
Thank you.
Thank you.
Bye.
Thank you all.